efficient because you're going to hear diverse opinions. Something that has sort of stuck in my craw, and I'm so upset that Ms. Alvarez did not join us, because I would love to know what has happened or will happen to the police officers who falsified the police reports in Laquan McDonald in the shooting. I'm just curious about that, because all of the other systems of justice rely upon those police reports as the foundation of what they're going to do next. So if it starts on a lie, you know, my grandmother said, if you build a foundation on sand, don't be surprised if it falls. So I'm curious, Donna, do you have any insight as to why we have not heard anything about it, and do you have any insight as to whether or not maybe the law is different here in Cook County? Maybe you can explain it to me. I haven't tried a case in a while, so you are the professor, you might need to explain it to me like I'm 6.
I tried to explain it to my daughter, and she's 11, and she got it. But, you know, we have sat through, in the last few weeks, listening to Anita Alvarez at the editorial boards and at a couple of other events, explaining to us how it took 400 days for her to do a meticulous and thorough investigation. Those are the words that she uses every time she's quoted. And there are 2 questions that she has not answered, which I have asked of her. The first question is, how meticulous and thorough an investigation did you do when after 400 days we only have 1 indictment against the shooter, when we know that we have 6 or 7 police officers that have lied on their police reports? The other thing that she has not answered and has been asked of her at both, I know the Sun-Times and I'm thinking maybe the Tribune, is this. What was it on day 400 when you indicted Officer Van Dyke? What was it that gave you probable cause? Because we're not talking about proof beyond a reasonable doubt at trial. We're talking probable cause to indict the case. What did you have on day 400 that you didn't have on day 30? And, you know, that's the problem. I don't think there's anybody, not only in this room, but in the whole county, that thinks that something good happened between October 20th, 2014, when Laquan McDonald was executed, and the day she indicted the case. And I don't think anybody thinks that this case would have been indicted if the judge was not going to release the videotape. Now, you know, a lot of people have said, well, why? You know, that's a question only Ms. Alvarez can answer. Whether, again, we have to have indictments based on evidence and not on influence, not on politics. So, was she trying to curry favor with the police department? I don't know. I could go back and give you 4 or 5 other cases that didn't get indicted, especially in an election year. So yeah, maybe she's trying to curry favor. What we have to hope for at a minimum is, if we don't see indictments coming out of the state's attorney's office on these police officers, that the U.S. Attorney's Office in their civil rights investigation will capture it in that regard. But as I said, it is an embarrassment nationwide, and actually people who've traveled overseas, worldwide, that we can't get our act together to do the right thing in the state's attorney's office.
Kim, I actually asked you this question before in a different forum. I thought, did a grand jury indict? Was there a preliminary hearing? Did something happen in between the day 30 and the day 401, as Donna would say? And I was told that Mrs. Alvarez filed an information, which is what she could have filed on day 2. You explain, please.
You keep trying to get us to explain the crazy. It's that there's no explanation that is sufficient. She didn't, you know, the confusion was, and people use the lingo, you know, he was indicted. He's since been indicted, but he wasn't indicted on day one. And so it's like a criminal complaint that you can file like easily, and then it will go to a hearing. That does not take impaneling a grand jury and having hearings that people don't know about for weeks or months. There were no grand jury hearings in Jason Van Dyke's case as it related to murder. There was none. So the reason that she was able to get the case filed after on Thursday that the video was announced that it was going to be released, and by Tuesday at 3 o'clock, 2 hours before the video was going to be released, that she was able to get it done. It was simply by choice. That was a choice that this state's attorney made, and that choice was made largely because the world was going to see that boy lying on the ground getting pumped with 16 bullets and ask, why didn't anybody do anything about that? So the thing that changed between day 30 and day 400 is the transparency of that video about to be released and all of us asking what happened here. What is also disturbing, what you alluded to about the 6 other officers who have yet to be charged, what we ought to be concerned with is the fact that these officers were still going to work and still investigating cases. And were they testifying in court? If we've now determined that the video shows that they were lying, if you knew 6 months ago, 6 days ago, 600 days ago that these are liars and they are going into courtrooms testifying under oath, and you've not alerted the defense attorneys or if you've not alerted anybody, the criminality of it, it goes wider. The concern that I have, again, when we talk about ethics and transparency and Inspector General oversight is, we had those police officers not only just on the payroll, but they were working. And for a number of the people who've had their cases in court did not know that the officer who may have been testifying against them in their trial where their freedom was going to be deprived was a liar. And we haven't pushed on those issues, and that has to be dealt with.
You know, Kim and Donna, it almost sounds, forgive me because it's my favorite show, it sounds like a Law and Order episode, because it's very clear to me, I mean, obviously I was being facetious that I didn't understand it. If the tentacles really were to reach as far and as wide as they are, with police officers lying under oath, and that document is indeed a sworn statement, and there are charges that come later where they are found to have perjured themselves, that will impact on every single case that they testified in and make automatic appealable issues. If that should happen, the criminal justice system on that foundation of sand in Cook County is going to be rocky, just so we know. I want to do just some quick questions just to get your response. Donna, do you support legislation prohibiting racial profiling in law enforcement?
I would support legislation. I think the harder thing to do is to actually have police officers adhere to it. You know, we pass laws all the time, but the problem is, how do we get people on the street? How do we get our officers to stop somebody properly, to frisk somebody properly? You know, we entered into a consent decree, the Chicago police with the ACLU, because stop and frisk was being misused. So the question is, yes, to support legislation, but the more important issue is, how do we translate that onto the street with our police officers? And for better or worse, you know, we have to really, really do education, sensitivity training. And the other thing I think that helps is, you know, between the state's attorney's office and the police department, if the officers understand, I mean, maybe I'm simplistic, but I think the goal is that we want to get the guys committing crime off the street. We want our streets safe. We want to be able to walk to the store. We want our kids to ride their bicycles. So if others think like that, if the police think like that the goal here isn't to arrest and convict the wrong person, and if they do joint training with our office to say, look, you stop somebody improperly, my case gets thrown out. You frisk somebody and get evidence improperly, my case gets thrown out. You profile improperly, my case gets thrown out. It gets thrown out if assistant state's attorneys do racial profiling, in essence, what's called the Batson case, when they're picking a jury. So if our goal is, in fact, to get the bad guys off the street, we need a lot more education and a lot more sensitivity to make sure that state's attorneys, as well as our police officers, understand what it takes to get a conviction in the courtroom. And that's, I think, what we have to do. Not only pass legislation, but actually make sure that it's taught.
You seem to be talking about a true cultural shift. Education and training is one thing, but if you have a bunch of people who go home to neighborhoods that don't have anybody that look like the people they're policing, their culture is going to fight you kicking and screaming to actually make a cultural shift. Kim, same question. Do you support legislation prohibiting racial profiling in law enforcement? And go after what Donna said. The hard part is trying to enforce it.
So yes, I do support legislation against racial profiling. The reason that you want the legislation is so that you can have some teeth to enforce it. So while it is the harder part of trying to get people to stop doing it, holding them accountable because they have broken a law makes it more, has more bite to it. The issue around racial profiling, you know, the ACLU report that Donna referenced showed that in Cook County, in Chicago, we were stopping and frisking African-American men on the south and west sides at a rate 4 times higher than what they were doing back in New York. Y'all do that in New York. And 4 times higher in African-American communities. And that it was wrong. And what was the result of it wasn't that we were stopping criminals, we were just stopping young black boys. And the problem with that is that it creates a distrust of police and law enforcement when you are continually stopping them. So if there is a ramification, if there is an accountability, if there is something that happens to you when you engage in a policy and a practice that has been outlawed, then there's more accountability. The cultural shift comes when you hold people responsible for their actions, and people are then less inclined to do it because they don't want to get caught up. And what's happened in Cook County, what's happened with our criminal justice system, like I said, you have a police commander who was found to have tortured people 30 years ago. And we still haven't dealt with the issue of police brutality. And so that culture doesn't change because it stopped happening. We stopped holding people accountable. We stopped saying, whether it's prosecutors or police officers, that you will be held liable and responsible for these acts. The cultural part, the having people in positions of authority that reflect the community that they serve, that diversity piece matters. And we're not seeing that. I go back to the fact that we have no black first chairs at 26 in California. So that when someone is complaining about the stop and frisk or the practices, who are they talking to? And what's going to happen as a result of that? And so when you don't have mechanisms and people in place to address these issues, and you don't have laws on the book to hold people accountable by, the notion that leadership change alone, absent like real accountability metrics, will not get it done. So you change the culture by changing the leadership, saying we're setting a new tone, and then if you are not with the program, you're not with the office.
So we're really talking about a major shift in the mindset of the state's attorney's office in Cook County. I'll go to you since you brought it up, and Donna also, are we looking at an office that, at least for now, even if either one of you are in place, that cannot police itself, or we are looking at needing a special prosecutor or independent counsel for cases that involve allegations against law enforcement and or people who are prosecutors in the office? And Kim, I'll start with you.
Yeah, I've been a proponent of special independent prosecutors in cases of police shootings. I think the evidence has shown, not just, again, with Laquan McDonald, but in history. If we talk about the number of cases that IPRA had involving police shootings and the lack of prosecutions, we have a problem here. And the issue is that the police department and the state's attorney's office have an intimate relationship. They have to. I'm not saying that to say that it's something nefarious about it. The police officers, as Donna talked about, that's where we get our cases from. There's a mutual relationship with the police department. So that when it's now time to hold the police accountable, and again, we talk about felony review, the state's attorney's office and the police department in charging those cases, they work just like this. They are intertwined. And you're now asking the same people who you work so closely with to charge you. And what we've seen in Cook County and why other jurisdictions, it's not just here. I mean, we are an embarrassment in the world and how we do justice here, but we are not outliers. Other jurisdictions dealing with issues around police shootings have said an independent prosecutor makes sense, and for the interest of fairness and transparency so the public can know that the police officers are being held accountable not by the people that they have an intimate relationship with. So, you know, the state's attorney will say, oh, you have to have a clear conflict of interest. You do. In the state's attorney's office right now, if one of our colleagues got arrested for a crime, the state's attorney's office does not prosecute them. Because people would say, how can you prosecute one of your own? The Attorney General's office prosecutes state's attorneys who commit crimes. It is not a stretch of the imagination to say that an independent prosecutor should be brought in cases of police shootings for the same relationship. If a secretary in my office gets an attorney general, certainly a police officer should. Donna?
So what happens is in all cases, not just a case of a fatal police shooting, in all cases, police and prosecutors are working together. And look, we've had cases where the police have lied on burglary cases, on assault cases. So the problem with always relying on a special prosecutor is we almost just need to get rid of the state's attorney's office and use special prosecutors, because injustice can happen in every case where the police and the prosecutors are working together if the prosecutors aren't vigilant. And not to mention, I mean, look at the Kochman case. You know, I think most people are familiar with it. It was where a well-connected white kid on Division Street got into a fight, one-punch murder. The case didn't get charged under Dick Devine. Anita was the chief deputy at the time. And the case continued, obviously, when she was state's attorney. It didn't get charged. They appointed a special prosecutor. You know, the problem is the special prosecutor, the independent prosecutor, is never independent as well. I mean, you know, Dan Webb has contributed to Anita Alvarez's campaign, so how independent is he? So my idea is this. You know, everybody's been calling for federal oversight. You know, as if the feds have some secret, and I don't know that they do, but I came out of the U.S. Attorney's Office as well, and what I would like to do is to form a unit in the state's attorney's office that is made up of former federal prosecutors. So these are not people that have worked day to day with the Chicago police. These are folks that would come over and do nothing but investigate police misconduct and police shootings. They would report direct to me. So they're not reporting through the chain of supervisors who also oversee the assistants that are in the courtroom every day. And in that way, you get rid of a lot of the BS of finger pointing. Well, this one said this or this one said that. So they're going to report direct to me, and I will make a decision as state's attorney whether to indict or not indict or what charge I'm going to indict on, and then issue a report to the public. So the public understands what the decision is. And in that way, there'll be transparency. Not everybody's going to agree with every decision, but the public will certainly understand why the decision was made. And I feel confident, you know, I'm not part of the establishment here. I'm independent. First time I've run for office. I don't have any of the usual Democratic Party leaders, whether it's Madigan or Preckwinkle, pulling my strings here. So I feel very comfortable in charging a police officer if that police officer needs to be charged.
So that I'm clear, Kim, you say independent counsel or special prosecutor, yes. Donna, you say independent prosecutor, independent counsel, or special prosecutor, no, you would want to keep it in-house, but do it as a separate trial unit within the state's attorney's office.
I think what we're just saying, just to be clear, is certainly not in every case. If there is a case where potentially there's also an assistant state's attorney involved in part of the cover-up, yes, then maybe we have a conflict, but certainly not in every case.
So back to the quick questions. Since we talked about transparency, I found it fascinating to learn that the Office of the Cook County State's Attorney's Office does not release statistical data to the public, specifically about cases, case status, case dispositions, demographics, etc. So basically, don't nobody know nothing. And I mean that they pay me to be able to make stuff user-friendly, okay? To break it down just real. Don't nobody know nothing, and nobody wants you to know anything. So do I have a commitment from both candidates here that that practice will indeed change?
Absolutely. As one who has been subjected to the state's attorney not knowing nothing about my record, absolutely.
Yes, we will be open and transparent, both because it instills public trust, but also, you know, when I first heard about this, I said, how can you not keep track of how many felony cases you indict and what the disposition is and whether they get reversed on appeal? How do you teach your assistants where the mistakes are? You know, look, everybody, we're in closing argument, you can't use this language. So, you know, and I know Kim and I have had this discussion before. It is amazing to think that we don't keep statistics. The only thing I would add is the few times when Ms. Alvarez has been here with us, she seems to have statistics at her fingertips. So I'm not sure how she has the statistics, but we don't get them.
You know, Amazon can tell me how many potty pad orders I have put in for my dog, and then they can suggest some dog food because of my potty pad order. Demographic information completely leads to what your future choices are, and every single place on earth right now tracks it universally. You cannot go on the internet without being tracked. They will actually stop you and say, yo, cookies are about to go in. If you don't want cookies, you can't come here. So that basically is it. Okay, next question. Gun violence. Does the state's attorney's office have any role to play in trying to reduce the incidence of gun violence? And if so, what role would you play?
The state's attorney has a key role in reducing gun violence. One of the things that we talk about in Chicago is the number of shootings and the number of deaths that happen on a daily basis here. And what we know is, and what we've talked about forever, is that the flow of guns into Chicago, because of weak gun laws around the area, contribute to the problem. That we've been told repeatedly that for every gun that we take off the streets, that there are 7 more guns that are picked up or that are brought into the community. What we don't know is that in 2015, there were 3 arrests for straw purchasing. 3 arrests. So no prosecutions. So the fact of the matter is that we don't proactively go after gun trafficking and to prevent gun violence. What we do is we sit and we wait for someone to be hurt. We sit and we wait for someone to be caught before we do anything. A reactive strategy to gun violence leads to what we see right now. One of the things that the state's attorney's office has to do is create a unit. I mean, she's very proud of the fact that there's a trafficking unit, human trafficking, but we don't have a gun trafficking unit in a city that has this much gun violence. That works in partnership with federal agencies to deal with the fact that we know where the guns are coming from, that we don't have strong legislation on licensing of gun shops in Cook County. I mean, there's some common sense things that we should be advocating for, and we should also be working with partnerships with the ATF and other agencies to deal with trafficking. One of the biggest things that I learned that was of concern to me was there's a freight train that goes through Inglewood that is broken into at least once every 3 months that has automatic weapons that are stolen from them. And there's been no efforts whatsoever to stop the weapons from being stolen. And some of this is just common sense. Maybe you station somebody there when it's sitting there, or maybe you report it. But literally, the police department sends out an alert 2 months after the fact. And so because we don't have a targeted strategic approach proactively around dealing with gun traffic, that is, I think, what leads to a lot of these issues of violence with guns here in Cook County. And I am going to establish a gun trafficking unit within the state's attorney's office.
What about increasing mandatory minimums? How do you stand on that?
I am not a proponent of increased mandatory minimums across the board. What we know is we've seen the historical data that shows that when you do mandatory minimums across the board, everybody gets caught up and everybody's treated the same. So first-time offender and fourth-time repeat offender are treated the same, and that's not what justice looks like. Now, I've talked about presumptive minimums where you have a floor, where you say if you've committed this type of crime, this is where the floor should be. But you can go below it if the judge makes a record. Tell us why you're doing it. A lot of what happens in Cook County is they impose sentences and there's no rhyme or reason. There's no explanation. There's no record to go back to determine why one judge will give you the max and one judge will give you the minimum. And what I'm suggesting is that mandatory minimums where everybody gets the same sentence does not have the effect that we think on violence. And it's been cited, New York, again, everybody thinks New York does great things. That they say that New York, that's what drove gun violence down. But it was a series of other implementations of policies as well. And here in Cook County, we have sufficient laws. What we don't have is accountability for the judges who impose them, nor transparency on how they make those decisions. And we need to go there first before we sweep up everybody in blanket reactionary politics.
Thank you, Kim. Donna, plan for reducing gun violence, is it in your purview? And mandatory minimums?
So I put out a gun violence plan about 6 or 8 months ago when I first started to run for this office, because to me, gun violence was the #1 problem. And the first thing I said was we need a centralized gun court, both in the city and in our suburban districts. The reason why is the gun trade is a food chain. We need to understand who's at the bottom of the food chain, who's in the middle of the food chain, and who the folks are that are actually doing the bulk of the illegal transporting and selling of guns into our community. It's no different than the drug trade. And if we have a centralized gun court, our assistants start to learn the gun trade, the judges start to learn the gun trade. And the reason why that's important is you have to be able to distinguish who made a mistake and who's going to be a career offender and who's going to be a problem. Now, Chief Judge Evans about 2 or 3 weeks ago came out with, he wanted to do a centralized bond court for guns. This would be actually a more broad-based gun court, not just in setting bonds, but taking the case from bond all the way to conviction. The other thing that you have to do in conjunction with having a specific courtroom or courtrooms for gun violence is we have to use our grand jury in a much different way. Right now, we use our grand jury to indict cases. But what we have to do, and it's something that the federal government, when I was in the U.S. Attorney's Office, does all the time, we have to use our grand jury to break the code of silence in our gun trade. And the way you do that is you figure out who your low-level offenders are, right? Because you really want the big guys, right? It's like when the feds prosecute Rod Blagojevich. They have to go up the chain until they get the evidence that's going to convict the governor. And you can put people in the grand jury and you can compel their testimony. And if they don't want to testify, you can hold them in contempt of the grand jury. And that's how you start to build your case against the very worst offenders who are bringing guns into our community. And that is something that we don't do stateside a lot, we do it all the time federally, and we have to start, again, everybody wants federal oversight, let's bring what we do in the U.S. Attorney's Office to the state's Attorney's Office. And the third thing we need to do are create neighborhood safety alliances. right? Our gangs are fractionalized, they're going block by block. We have to have real communication and alliances, because this is a community-wide problem, and the state's attorney in and of herself is not going to be able to solve it. We need parents and teachers and police and aldermen and prosecutors and our clergy, our not-for-profits, and even our private corporations to maybe give some money to be able to sit around a table and say, look, we know who the offenders are, we know who the potential victims are. You know, one of the mayors in a North Side community told me they're moving out victims because they know who they're going to be. So we have to communicate. We're not communicating.
Thank you very much. I actually have some questions from the audience that I'd like to go to. These have been put forth by members of the community who are present here. And I will read the question in its entirety. Why are so many black men in Chicago in jail? What do you imagine you can do to change or decrease the number of men in jail here? I'll start with you, Dawn.
So the office, as we've talked about, needs to be consistent in how it applies the law. And right now, I think, again, we don't have the statistics, but anecdotally, what you will find is that cases in the city are handled much different than some of the cases in our suburban courtrooms. And what happens is that cases will get reduced up in Skokie or in Rolling Meadows, but they don't get reduced in the city. And what that leads to is, for the same, let's say, low-level nonviolent crime, it leads to a disproportionate number of black and brown men going into Cook County Jail than it does from Rolling Meadows or Skokie. And so that's why we need the consistency to be able to, and the transparency to be able to say, look, here, if it's a first-time offender and we're going to do a reduction on a felony charge, and we're going to give an I bond, an individual recognizance bond, and not put somebody in Cook County Jail awaiting trial, then we have to do that across the board. And again, referring back to the Kochman case, you know, the problem with that case was, you know, the well-connected white young man doesn't go to jail, or goes for 60 days. You know, took 8 years and $2 million of a special prosecutor to do it, and yet we have a black young man in Englewood gets charged with first-degree murder in 48 hours. So that's the problem.
All right, Kim, your turn.
I mean, I think we have to call out the fact that there's institutional racism in our criminal justice system.
Yes.
And to not say that means that we're not gonna fix it, right? When we talk about transparency and accountability, what you have to do, it's not a matter of let's charge people in Englewood like we charge people in Skokie. Let's maybe not charge some of the people in Englewood, period. That what we're seeing is that there are issues, and particularly I'll go to juvenile justice. What we find is that in schools in African American communities that are underfunded, under-resourced, and in high concentrations of poverty, the statistics tell us that those behaviors, those what we would call delinquent behaviors, become criminalized. So when you have 12, 13, 14-year-olds who are getting arrested in the schoolhouse for fighting with an aggravated battery, and they are now getting fingerprinted and mugshot and on the pipeline to the prison complex at a rate that is different than any other community, we have a problem.